by the Georgetown Federalist Society. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rarely remembered as the great expounder and defender of the Constitution. Our resolution tonight is, may the states protect their own borders. As Texas Governor Greg Abbott recently declared, quote, one of the most crucial rights granted in the U.S. Constitution is a state's ability to secure its own border, including in the immigration context. The Biden administration, which is now suing the state of Texas over this issue, disagrees. With immigration and the border being top of mind for most Americans, serious and nuanced debate on this subject is more important than ever. To discuss this critical question, we welcome three outstanding leaders: the great Judge Lawrence Van Dyke, the amazing former Arizona Attorney General Mark Brnovich, and the brilliant Scalia Law Professor Ilya Somin. We are deeply grateful to the Federalist Society and to Georgetown Law for making the Daniel Webster debate series a reality. I now recognize Madeline Malone, our Director of Clerkships, to introduce these three stellar panelists. Please give our speakers a warm welcome.
The Honorable Lawrence Van Dyke will be moderating our debate. He serves as a circuit judge on the United States Court of Appeals for the Ninth Circuit. Prior to that appointment in January 2020, he served as the Deputy Assistant Attorney General in the Environment and Natural Resources Division of the United States Department of Justice. Before that, he served consecutively as the Solicitor General of two Western states, Nevada and Montana. At the beginning of his legal career, he worked as an attorney in the Appellate and Constitutional Issues Practice Group at Gibson, Dunn and Crutcher. Judge Van Dyke received his law degree magna cum laude from Harvard Law School, where he was an editor on the Harvard Law Review. He has engineering and theology undergraduate degrees and a master's degree in engineering management. He served as a law clerk to the Honorable Janice Rogers Brown of the United States Court of Appeals for the District of Columbia Circuit. Mark Brnovich is a partner at Boies Schiller Flexner and previously served as Arizona's 26th Attorney General from 2015 to 2023. Mr. Brnovich was an Assistant Attorney General with the Arizona Attorney General's Office from 1998 to 2003. Mr. Brnovich later went on to serve as an Assistant United States Attorney for the District of Arizona. He has also been a Judge Pro Tem of the Maricopa County Superior Court, a Command Staff Judge Advocate in the U.S. Army National Guard, the Director for Constitutional Government at the Goldwater Institute, and the Director of the Arizona Department of Gaming. Mr. Brnovich has been recognized by the National Federation of Independent Business as a champion of small business, and was elected by his bipartisan colleagues to serve as the chairman of the Conference of Western Attorneys General. He received his BA cum laude in political science from Arizona State University and his JD from the University of San Diego Law School. Professor Ilya Somin is professor at George Mason University and the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute. In addition to being the author of many scholarly books, Professor Somin's work has appeared in numerous scholarly journals, including the Yale Law Journal, Stanford Law Review, Georgetown Law Journal, and others. Professor Somin has also published articles in a variety of popular press outlets, and his writings have been cited in decisions by the United States Supreme Court, multiple state Supreme Courts and lower federal courts, and the Supreme Court of Israel. Before joining the faculty at George Mason, Professor Somin was the John M. Olin Fellow in Law and Smith of the U.S. Court of Appeals for the of Northwestern University Law School. He clerked for the Honorable Judge Jerry E. Smith of the U.S. Courts of Appeals for the Fifth Circuit and earned his BA summa cum laude at Amherst College, MA in Political Science from Harvard University, and JD from Yale Law School. Please welcome our speakers. Judge Van Dyke, we'll turn it over to you.
Thank you, Madeline. What she did not mention, and I don't know if she's embarrassed about it, but Madeline's going to clerk for me in a couple of years here. So I hope I didn't get you in trouble by saying that for the rest of your time here, Madeline. It's a real honor to be here. This is obviously, it's nice to see the turnout, and I'm sure we have some folks online too. And it's nice to able to talk about something that's obviously a very timely and important issue. There was a debate last night also that I'm sure many of us watched, and there was some discussion of issues like this in that debate last night. So obviously the issues on a lot of people's mind is illegal immigration is widely perceived right now as being a crisis and having wide-ranging effects. I'll leave it to the panelists to talk about more specifics about that, but I don't think anybody can deny that many have see it, and probably maybe even a majority of our country see it as one of the leading challenges in America today. The challenges are very wide-ranging. I've experienced some of them as a judge on the Ninth Circuit. A very significant portion of our docket is immigration cases, and it's a very significant part of what we do. It takes, it's a huge resource requirement for our circuit. It can be divisive. I've written opinions where I've been dissenting, and I've also written opinions where others have dissented, and so it can be a divisive issue. Some of these are high-profile cases. It puts the federal government and state governments, as we'll talk about this evening, in tough positions. Some of these issues do. There's the human toll aspect, which I hope will get mentioned tonight. And so there's just a lot going on with these issues. But tonight, the panelists are going to discuss and debate a particular facet of the problem, and that is what can states do about the problem, and specifically what can states do to or can't do to protect their own borders. Now, there's a lot of tensions inherent in immigration law and policy, but tonight's debate will focus on at least one major tension, and that is the fact that under our system of government, the federal government has the primary, and some would say almost exclusive authority over U.S. immigration law and policy, but state governments bear a significant and, again, arguably most of the downstream effects of that policy. And there's good reasons to give the federal government primary authority. We want to speak with one voice as much as possible to foreign governments and to speak with one voice internationally. And there's also the concern that if states, each one if these various border states controlled immigration policy, then obviously what one state would do would have significant effects on the nation as a whole, and obviously all the other states in the nation. So those are all good reasons for the federal government to have primary authority. But the effects of immigration decisions on the states are also obvious and I think incontrovertible. You end up with the increased use of government programs, the increased use of government provided or subsidized health care, the increased use of criminal or crime fighting resources by the states, law enforcement, strains on public education. All of these aspects of immigration are felt by the states. So it's understandable that when the states perceive the federal government as shirking its immigration duties or responsibilities and failing to enforce the federal immigration law, then state leaders are going to feel a strong impulse to do something about that and do whatever they can to fill the void. And what I think our debaters are going to talk about tonight is what is it that they can do? What is the power that they have? But hopefully, I also hope they'll talk about what they should do. So even if we don't, if somebody says we don't have the authority to do something, maybe some prescriptions for what kind of laws should be changed. Now, to set the table for this, and then I want to get out of the way, I want to provide the language of some relevant constitutional provisions and then a very brief description of some of the key cases so that hopefully when the debaters are talking and they're talking about these cases, you have an idea of what they're talking about if you don't already. So first off, Article 4, Section 4 says, of the Constitution says, the United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion. That's the part that is relevant. And on application of the legislature or the executive, when the legislature cannot be convened, against domestic violence. And then Article 1, Section 10, Clause 3 says, no state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded, or in such imminent danger as will not admit of delay. And so that's sometimes referred to the invasion clause. And that's going to be, I think, an important provision referred to tonight. There's 3 recent high-profile lawsuits that involve these issues. None of them are in my court, thankfully. All of them are in the Fifth Circuit. Just to quickly preview them so that hopefully the debaters can easily refer back to them and you know what they're talking about. I think you'll probably be referred to often as the buoy barrier case, the razor wire fence case, and the SB4 case. But United States versus Abbott is the buoy barrier. And that's where Texas installed a 1,000-foot or so buoy barrier in the Rio Grande River at the border near Eagle Pass. And that was challenged by the federal government in federal district court in Austin. And the main part of the challenge was that it violates the Rivers and Harbors Appropriation Act of 1899. So it's a statutory violation. They're saying Texas is violating federal statute. And because it's an unlawful obstruction of the navigable capacity of the waters of the United States, the district court granted a preliminary injunction. The Fifth Circuit three-judge panel affirmed that injunction with Judge Willett dissenting from the Fifth Circuit. And then the Fifth Circuit took the case en banc and reversed that in favor of the state of Texas. And the majority for that en banc panel, it addressed basically the statutory argument and disagreed and said that it did not violate the Rivers and Harbors Appropriation Act of 1899. It did not really address Texas's defense. Texas, said we don't violate the Rivers and Appropriations Act, but even if we did, the evasion clause gives us the authority to do what we're doing. And of course, the evasion clause in the Constitution trumps federal statutes. So that was their defense, sort of their backup defense. The majority did not really address that. They never reached it, so to speak. The district court judge had, though, because obviously to rule against the state of Texas, you needed to address all of it, and said that it was a non-justiciable political question. And the mandate in that case, as I understand it, issued in September of 23. So I doubt that's the end of it. What the Fifth Circuit said, we may be hearing from litigation in the Supreme Court. Second case is DHS, or Texas versus the Department of Homeland Security. That's the razor wire fence. Texas installed more than 29 miles of, I never can say this right, concertia wire. The really sharp stuff you don't want to fall into, along sections of the Rio Grande River on the border. The U.S. Border Patrol was cutting and destroying it in various ways, and Texas sought an injunction. So in this instance, Texas brought the lawsuit and sought an injunction in federal court to stop that, claiming, among other things, the common law trespass to chattel, which hopefully is like they're stealing stuff or they're destroying our stuff, basically. And the same thing you might do if your roommate does bad things to your things. In this case, your roommate's the federal government. So the district court denied the preliminary injunction on sovereign immunity grounds, so ruled against Texas. The Fifth Circuit granted an injunction pending appeal in favor of Texas. And in this case, the Supreme Court vacated the injunction in a 5-4 decision, so ruled in favor of the federal government, obviously in a temporary capacity. The Fifth Circuit heard oral argument on June 6th, and no opinion is issued in that case. So right now, that's where that case stands. And then the last case is United States versus Texas. The SB4 cases. Texas passed a law, Senate Bill 4, SB4, making it a crime to enter Texas from Mexico anywhere other than at a legal port of entry. The district court enjoined that. It was the same judge as the Bowie case. So that judge enjoined the SB4, saying that SB4 conflicts with federal immigration laws. The Fifth Circuit issued an administrative stay of the district court's injunction. So stayed the injunction, so let the law go into effect. And then the Supreme Court refused to vacate the stay in a 6-3 decision. But then barely a week later, the Fifth Circuit removed the stay pending appeal. And the Fifth Circuit panel concluded that SB4 is likely preempted. So this is the preliminary stage. This is the appeal of the preliminary injunction. So it said it was likely preempted by federal immigration laws. And then tersely, and then again, Texas had the backup argument, said their main argument is, of course, we're not preempted. What we've done is not, our SB4 is not preempted by federal law, but even if federal statutory law preempts SB4, Constitution trumps the statute, this federal statutory law, at least as applied in this instance, the evasion clause. And so that was what Texas argued, but the majority obviously had to deal with that, but tersely rejected it, if I recall correctly, in just a few paragraphs. And then Judge Oldham dissented, as I recall. Judge Oldham did not address the invasion clause, so it just said it's not preempted. And the Fifth Circuit heard oral argument on April 3rd. I think that's in the on the merits of the issue. So these cases are crazy because you have an appeal of the preliminary injunction and then you get an appeal of the actual merits. I think they heard oral argument on April 3rd on the merits, and there's been no Fifth Circuit opinion yet on that. And with that background, I'm going to turn it over in a moment to my impressive panelists. As we mentioned before, we're going to have about 7 minutes plus or minus. And I think we're going to first hear from General Brnovich and then from Professor Soman. And then we have a few minutes of optional rebuttal time from each of them. I fully expect them to take advantage of their optional rebuttal time. And then I'll have some questions, but please be ready to ask questions from the audience because I always like to have audience participation. All right, can you hear us, Mark?
Yes.
Fire away.
You're good, you're good.
Thank you for having me here this evening. I apologize for not being there in person, but as they say, there was the proverbial miscommunication or scheduling conflict. And I would love to have been there in person, especially because Georgetown is such a wonderful education institution. You're all very fortunate to be going there. Many of you will have a great impact, not only on the law, but on this country as well. And let me give you a piece of advice that someone told me years ago when I was just starting off with the law. And that is, a good lawyer knows the law, a great lawyer knows the judge. So I do want to begin by thanking Lawrence for that beautiful introduction. I'm sorry, I'm actually married to a judge, and I know you're not supposed to address them by their first name. So let me just say, Justice Van Dyke. Sorry, not Justice yet, Judge Van Dyke. Thank you very much for that wonderful introduction. You know, I am the embodiment of the American dream in many ways. You know, I'm a first generation American, I'm a public school kid, and yet I was fortunate enough to be elected not once but twice as the Attorney General for the state of Arizona, even though I've got a funny last name and a name people still have difficulty pronouncing. I've been able to, you know, serve our country in various ways as a judge advocate general in the reserves, as a federal prosecutor, as a state gang prosecutor, and even having the ability to argue several times in the United States Supreme Court. But as I sit here today as a former prosecutor, I am worried about what is happening at our southern border. The reality is it is unprecedented. We know that the gangs and the cartels have seized operational control of our southern border. We know that there's a record amount of drugs flooding into our country. We know that people are being victimized, not only the migrants coming in, but victimized through human and sex trafficking. And it is having an incredible toll on our country. And we've heard all the anecdotes, but let's just take a quick look at the numbers. Just this last week, ICE released numbers indicating that there are 425,000 convicted criminal migrants right now in our country. Think about that. Nearly 500,000 criminals that we have let into our country. And more than 200,000 migrants have pending criminal charges. Of those that are in the country already, we know that at least 13,000 have been convicted of homicide, and more than 15,000 have been convicted of sexual assault. Now we know that predators like murderers and rapists often commit crimes again. In fact, the majority of the time they will. So think about that impact just on those numbers we'll have in our country. And in addition, we also know as the result of the flood of drugs coming into our country, fentanyl is at a record low price, and we've seen 100,000 Americans losing their lives every single year to fentanyl and opioid overdoses. Now, I believe the remedy, and I issued a legal opinion on this as AG, is that the states can declare an invasion and they have the ability to protect themselves. How does that happen? First, you have the State Self-Defense Clause in Article 1, Section 10 of the United States Constitution. And that provides that states may defend themselves when they have actually been invaded or they're in imminent danger as to not admit delay. And the state does not need consent of Congress to do so. The invasion clause in Article 4, Section 4 provides that the United States shall protect each state against an invasion. Now, these two clauses taken together provide protection against invasion as broadly defined. And this includes defending actions by not only foreign hostility and ambitious or vindictive enterprises or states' more powerful neighbors. It also encompasses a defense against hostile non-state actors such as the cartels and gangs operating at our southern border. Furthermore, the Import-Export Clause of Article 1, Section 10 recognized that states retain a sovereign authority to execute inspection laws which require operational control of their borders, and they have the ability to channel goods to authorized ports of entry. This is an aspect of the historical police power that states have exercised since even before this republic was founded. In sum, both the power of self-defense against actually being invaded, and the power to execute their inspection laws are sovereign powers that were retained by the states under the U.S. Constitution to permit states to control on-the-ground conditions at their borders, and they are essential to public safety and security in a state. And let us not forget, the states created the federal government. The federal government didn't create the states. Now, the on-ground violence at our border and the lawlessness is being caused by cartels and gangs. It is extensive, well-documented, and persistent. Therefore, it satisfies the definition of actually being invaded and invasion under the U.S. Constitution. Now, two conclusions flow from this. First, the federal government has a duty to protect states under the Invasion Clause. And second, when the federal government fails to meet its constitutional duties, states retain the independent authority under the Self-Defense Clause to defend themselves against being invaded. There is nothing in federal constitutional or statutory law authorizing the federal executive to stop or thwart states from ensuing on-ground safety and have an orderly border within their own state's territory. Nor is there any conflict with this and the orderly conduct of immigration policy on the federal level by the executive. No state should ever be put in the position like states like Arizona have, where the federal government's recent inactions and encouraging and facilitating illegal immigration has caused great strain. Now, the reality is the federal government is failing to fulfill its duties under Article 4, Section 4 of the Constitution to prevent states from invasion. Therefore, that clause exists precisely for this situation, so the states have their ability to defend themselves. Now, the federal government, as I said, was created by the states. So when the federal government refuses to do its job, the states have an obligation and the authority to protect themselves. So I hope everyone has an understanding that this isn't about whether you want more immigration or you want less immigration. What it is really about is when a state's borders are being overwhelmed and when cartels have seized operational control, what can the states do to protect themselves? And in my opinion, it is to declare an invasion and ensure that police powers and public safety are followed within a state's borders.
Well, thank you, Mark. Just give him a hand. I should mention one other thing that I forgot to mention, that I do think, and Ilya could probably confirm this or not, I think that the Texas governor did actually issue like an executive order to declare an invasion, I think. So that this is a situation where at least they've done that, and then
that is correct. He has done that.
And so we'll hear now from Professor Solomon.
Thank you to the Georgetown Federalist Society for organizing this event, and all of you for coming, and to the judge and the former Attorney General for their participation. There are obviously a bunch of issues in these cases. Like Mr. Brnovich, I'm going to focus on the invasion question, saying that is the biggest and most far-reaching issue. But I will also at the end talk more generally about how the best way to deal with our border issues is not to crack down or to declare an invasion, but rather to make legal migration easier. We should also think about getting rid of the war on drugs, which has also been a serious cause of our problems both at the border and in American society more generally. So as the judge said, Texas has argued in these three cases, among other things, that illegal migration and drug smuggling qualify as an invasion, triggering the state's authority under Article 1, Section 10, Clause 3 of the Constitution. And the issue arises, well, what counts as an invasion? And to my mind, and also that of the Founding Fathers, an invasion has to be an act of war. That is an organized armed attack. It's not enough that there be illegal migration or drug smuggling or other kinds of ordinary criminal activity. And you can readily see this from the text of the Constitution. After all, what can states do in response if there is an invasion? They can engage in war. We don't usually start a war over illegal migration or drug smuggling. Like it seems like starting a war would be a disproportionate response to something like that. And if you look at other mentions of invasion in the Constitution, it also certainly looks like a circumstance like war or large-scale armed conflict. For example, it is elsewhere paired in the Constitution with domestic violence, which in the 18th century meant not violence in the home, but like a domestic rebellion. And in the suspension clause, which authorizes the suspension of the writ of habeas corpus, invasion is paired with rebellion, which is also a large-scale war. I, with the help of my research assistant, have canvassed all references to invasion at the Constitutional Convention and also in the ratifying conventions for the Constitution, the usual most important sources for original meaning. None of them refer to either illegal migration or smuggling as a form of invasion, even though certainly smuggling was a big issue actually at the time of the founding. They all seem to refer to it as a kind of act of war. Indeed, James Madison, the father of the Constitution, in what is the clearest and most on-point founding era discussion of the meaning of invasion with respect to immigration, he specifically said immigration is not an invasion, rather invasion is, quote, an operation of war. So what Vladimir Putin is doing to Ukraine, that's an invasion. What Hamas did to Israel is an invasion. You can think of other historical examples. The Pearl Harbor attack was an invasion, but illegal migration is not an invasion, nor is drug smuggling, and that is true regardless of whether organized crime is involved or whether it's unorganized. I think it's actually not true that cartels have quote-unquote operational control of the border, at least not if operational control means that they decide who goes in and who doesn't. Most migrants come in regardless of what the cartel wants. They're not somehow cartel operatives, but certainly there are drug smugglers and cartels operating at the borders. Anytime you have a large black market, you're going to have organized crime involvement. That has been true throughout the history of the war on drugs and before it, prohibition. That doesn't mean that it qualifies as an invasion. It's just an ordinary law enforcement issue. I would add that if Texas were to prevail on this argument, it would have dire consequences that go way beyond the specifics of these cases dealing with buoys or concertina wire or other similar issues. Because recall, what can states do in response? They can engage in war. That means that anytime there's large-scale illegal migration or drug smuggling, any border state or possibly even an interior state, since these substances and migrants do go into the interior afterwards often, that they could start a war with a foreign country without Congress's consent, thereby dragging the entire United States into war. And this isn't even just a theoretical hypothetical that clever law professors can come up with. A number of important Republican Party politicians have actually advocated military intervention in Mexico to more effectively wage the war on drugs. So this is something that could actually happen if states had this power. The other thing that could happen is, recall the suspension clause, which says that in times of invasion, the writ of habeas corpus can be suspended. Those of you who have taken intro con law, you probably know what that is. But in case you don't, that means that you can be detained without charges or trial in violation of what would normally be your civil liberties. I don't know about you, but I don't trust Kamala Harris or Joe Biden or Donald Trump or any other politician with the power to do that at any time they want, and they would have the power to do that anytime they want if illegal migration or drug smuggling qualifies as an invasion, because throughout the history of migration restrictions and also throughout the history of the war on drugs, we've always had substantial drug smuggling and substantial illegal migration across the southern border. So this argument is essentially a blank check to suspend a writ of habeas corpus anytime the federal government might feel like doing so. Now, it is sometimes argued, well, there is an invasion because there's a threat of terrorism or criminal violence and the like, but the actual number of Americans killed by terrorists who crossed the southern border over the last 50 years, for which we have data, that number is zero. So that doesn't mean the risk is zero. It does mean, however, that it's nowhere near enough to qualify as an invasion under any plausible definition thereof. Similarly, of course, there is ordinary criminal violence at the border, and of course, some illegal migrants commit violent crimes. That certainly deserves to be condemned. The people who do it should be punished. Nonetheless, illegal migrants actually have a lower violent crime rate than native-born Americans do. The state of Texas's own statistics show that, and the data that Mr. Bernovich mentioned is actually misleading. Those 425,000 criminal illegal migrants, they're not those that crossed just recently. That's 400,000 still living migrants from or present in the United States from regardless of when they crossed. Actually, there were already 368,000 such people when President Trump took office in 2017. And so since then, these last 8 years, numbers increased by 57,000. And many of them are not even like roaming the streets, because this is a statistic for whether people who are not in ICE custody. However, they're counted that way even if they're, for instance, in a state prison. So if you're most of those 13,000 murders he mentioned are actually sitting in state prison. In federal data, that means that they're not in federal custody, but that's not much consolation to them if they're in fact sitting in a state prison. So in the last part of my remarks, just like to brief ask, well, what can we do, states and the federal government, about issues at the border? To my mind, we should recognize that those issues are primarily caused by the fact that we've created a large illegal market for drugs and also with migration by blocking legal pathways for most of those people who want to take them. And quite predictably, this results in a large illegal market. Just as when we had alcohol prohibition, there was a large illegal cross-border market in alcohol. And of course, what ended the problem of Al Capone and other organized criminals involved with alcohol smuggling? It was the end of prohibition. So similarly, if we make legal migration easier, we would have fewer problems with the illegal kind, and also we would create immense benefits for both migrants and Americans. Obviously, many of these migrants, they're fleeing horrible tyranny, including in communist countries like Cuba or socialist states like Venezuela. I'm old enough to remember a time when conservatives welcomed people fleeing communism. I'm one such person myself. If we were to adopt that policy today, we would eliminate much of the problem with illegal migration at the southern border, and also migrants could contribute more to the American economy and society. They disproportionately contribute to entrepreneurship and scientific innovation. They also lower both federal and state budget deficits. For example, the Congressional Budget Office recently estimated that the increase in migration over the last 3 years will, over the next decade, save the federal government or reduce its deficit by almost $1 trillion. We could have more of that and also fewer problems at the southern border. I won't hide from the fact that in addition to being a skeptic about migration restrictions, I'm also against the war on drugs. So the easiest way to solve the problem with fentanyl is simply to legalize. That would eliminate the role of the cartels and other criminals, and also it would reduce the problem that we currently have where the so-called iron law prohibition indicates that when you have prohibition over time, there's a trend towards people taking harder, more powerful drugs. And as a result of that, they become more lethal. With legalized markets, that problem is reduced. But if you disagree with me on that, still, you could liberalize migration, but for example, say you can cross the border so long as you show you're not carrying any illegal drug. Finally, I suppose I should briefly note an argument that Mr. Bernovich made that I had not heard before, which is the argument that states have a power of inspection laws and the like, and that enables them to restrict migration. What I would say to that is, if it's a power over the import of goods, this is actually a power that belongs to the federal government under the Foreign Commerce Clause, which specifically delegates power over foreign trade to the federal government, so that this is not a state power that can trump federal power, but at least it's a less dangerous claim than the claim that illegal migration qualifies as invasion, because at least here there's not a claim that states can wage war in response. So more can be said, but for now I conclude, and I very much look forward to a discussion. Thank you.
Thank you, Ilya. Mark, I assume you don't, I assume you agree with him that we should legalize fentanyl. And have no other disagreements, but if you do want to have any rebuttal time, feel free to take it now.
Well, it was funny, Judge, because I'm on a tight schedule and I was not going to do a rebuttal, but like any good litigator, I feel the need to do one now. So let me just say a couple things. It's always great hearing from the professor, and but I do think, with all due respect, that he did make a little bit of a straw man in his argument, because this really isn't about immigration. As I mentioned, I'm a first generation American, and I always start with the fundamental premise that when people don't want to come to America, that's when we have a problem. So there's nothing wrong with immigration. It just has to be done in a lawful and orderly fashion. And what is happening now at our southern border is neither lawful nor orderly. And instead, what has happened is we have handled control of the southern border to the cartels that are exploiting people, that are committing violence, and literally gangs are coming into our country. Now, a couple things I want to say, just for legal argument's sake. Let's just talk about a couple things. One of the things the professor failed to mention was that in Federalist 43, James Madison explained and talked about the invasion clause. And he said literally, quote, "It's a protection against invasion from every society to the parts composing it. The latitude of the expression used here seems to secure each state not only against foreign hostility, but against ambitious or vindictive enterprises or more powerful neighbors." Furthermore, this argument is continued in James Madison in Federalist 44, and you could look that up. During the Virginia ratification debate, James Madison specifically referred to smugglers, people that were smuggling rum and other illegal goods into the state, and that the state of Virginia, of course, would have an ability to go after pirates or smugglers and not have to wait for their state to essentially be invaded. Furthermore, when we look back at our sources, when we look at words of invasion, the professor wants to include new terms in the Constitution that aren't there. For example, even we know the Constitution, has provisions for, when war and how war can be declared, but he wants to impose additional definitions. And I would just refer back to, for example, the Webster's Dictionary of 1806. And this was the first American English dictionary, and the word invade was defined there. It was defined very broadly. And in fact, it begins by talking about to enter or seize in a hostile manner. Webster's 1828 dictionary also defines invasion very broadly to include not just the entrance of a foreign army into a country, but also to enter any country as an enemy, to be viewed to conquest or plunder or to attack, to assail, to attack, to infringe, to encroach, or to violate. So when we look back at the constitutional debates, Federalist 43, Federalist 44, the plain language of the Constitution, and what those words meant at the time of the ratification, clearly states have a right to defend themselves when the federal government refuses to do its job. Now, I would just add, I want to add a little more context to when we talk about this. As I said, this isn't about immigration. It's about a state being able to secure its own borders. And the professor noted, or he's talking about these different crime numbers. I will just say that we know for a fact that a record amount of people on the terror watch list have been apprehended, and every year, exponentially over the last few years, since the Biden administration started opening the border. Secondly, if you talk to people in law enforcement, federal officials, literally last week I was talking to federal officials who are down on the border, and they said what keeps them up at night is not just the people on the terror watch list that are trying to come through a port or an entry or border crossing, but it is the people that are terrorist suspects that they can't confirm, but they believe may be involved in terrorism or have hostile intent, but because they may have a common name or they can't confirm their identity, these are people being released into our country by the tens of thousands. And very often, you hear stories, if you talk to Border Patrol agents, the people in ICE, Homeland Security, people are cutting off ankle monitors. They're in the interior of this country, and we have no idea where they're at or what they're doing. And also related to that, what should keep everyone up at night is the gotaways. Now, right now in this country, you can literally go to a border crossing and essentially be allowed entry into the United States and get a hearing 4 or 5 years down the road. But every single month, tens of thousands, literally hundreds of thousands, almost a million, I don't want to throw out the numbers, but hundreds of thousands of people have are what's called gotaways. These are predominantly young males between 18 and 35 that are entering Arizona, Texas, through desert to the heat, that essentially are willing, are trying to do everything they can to evade capture. And you have to ask yourself, if you know you can come across the border and be paroled or let into the United States, why are hundreds of thousands of males 18 to 35 are willing to risk their lives and get in high-speed cars pursuits and do everything they can to avoid law enforcement detection? So it's not a matter of if, it's a matter of when the next terrorist attack is coming to the United States. And if you talk to anyone in law enforcement, they will tell you there are cells right now in this country as a result of the failed border policies.
Thank you, Mark. Ilya, you want to cede your time?
No, as the previous speaker said, like any good litigator, I'm going to exploit my rebuttal time for all it's worth. And I'm going to focus on a couple of broad issues. One is the definition of invasion. Then there's the question of terror watch lists and risks. So none of the sources he mentioned actually even come close to suggesting that invasion, as used in the invasion clause and other provisions of the Constitution, includes illegal migration or drug smuggling. The reference in Federalist 43 certainly doesn't say that an invasion can be anything other than an organized armed attack. Rather, it makes the point that the invasion clause protects not just against invasions by foreign powers, but also against states fighting each other. So if, for instance, Nevada were to try to invade Arizona or vice versa, then this would apply. The references at the ratifying convention, which have been much cited in this litigation, they are not actually references to the invasion clause at all. They're references to the power to call out the militia to enforce the laws. So yes, a state government, and in some cases the federal government, could call out the militia to enforce ordinary laws. That is different from saying that a state can use the invasion clause to engage in war in response to illegal migration or drug smuggling or anything of the sort. Now, it is true that there are some founding era dictionaries which give various definitions of invasion, including some broad metaphorical definitions, which say just an encroachment on rights or the like. And of course, we have that today too, that people talked about the British invasion of British rock stars that came to compete with American rock stars. But the word invasion, like any other word, it draws its meaning from context. So in a context, when it's paired with things like rebellion or the like, or domestic violence, the 18th century definition of domestic violence, not the modern one, we know in that context it's referring to an act of war, even though in some other contexts, like invasion of privacy or a British invasion or others, it can refer to other sorts of things. And every founding era reference at the time of the drafting of the Constitution and ratification strongly indicates that the invasion clause, the use of the word invasion there, is references to acts of war, even though certainly both in the 18th century and today there were metaphorical uses of invasion that mean other kinds of things. If it meant things beyond the act of war, like drug smuggling or migration or whatnot, given the dire consequences that would be triggered, a state could start a war on its own. The writ of habeas corpus could be suspended at any time. That is something the people in the founding era would have mentioned. We would have said, hey, maybe we don't want to give the federal government the power to suspend a writ of habeas corpus at any time they feel like, and yet that wasn't mentioned, and that's quite significant. Now, terror watch list, yes, There is evidence people on the terror watch list have entered, but as my Cato Institute colleague Alex Nevrastek has described in his publications on this subject, the name terror watch list is highly misleading, and most of the people on it are not even actual terrorists, and certainly not people who plan acts of terrorism against the US. Rather, most of them are people who have some vague connection or suspected connection to some insurgency in another country, in many cases not even an insurgency that had anything to do with the United States. And you can talk about, why do people evade the border patrol if they're not terrorists or criminals? I suspect it's because they don't want to get caught and deported, and because they want to enter the United States and escape the terrible conditions that they're fleeing. If there really was this great risk of terrorism, we should see actual acts of terrorism going on at some significant rate, and in reality, we see almost none. So that doesn't mean the risk is zero. It does mean the risk is nowhere near enough to justify calling it an invasion, and we could reduce the risk further by making legal migration easier and redirecting the vast resources currently used to try to prevent migration to conventional law enforcement, such as having more police on the street, which a lot of the data show can reduce crime of various kinds significantly, whether it be by immigrants or by natives. So more can be said, but for now I stop and I look forward to the questions. Thank you so much.
Thank you, Your Honor. Thank you, Alex. I want to ask both of you a question, and sort of, I think the question I'm going to ask you is a little bit of the flip side of the one that I asked the other debater. And so I'll start with Ilya. I'll start with your question. So what would you say to someone who says, okay, let's just accept for the sake of argument that it would be better if we just had the more the libertarian solution of not having all these restraints on immigration and just open things up. But before I'm willing to do that, I want to see sort of the system get fixed first, in the sense of I don't think it would be your position, and you correct me if I'm wrong in your answer, but I don't think it's your position that we want to keep out a bad person, a hardened criminal, a cartel member or something like that, or someone who's actually on the terrorist watch list because they're a terrorist and a threat to the United States. So we want to keep those people. So we want a system, even if it was a very open system. I assume that you would think that at least there are some people we want to keep out. And right now, our system doesn't seem to be very good at that. And so, what would you say to somebody who says, "Okay, I'm open to allowing creating more lawful pathways, et cetera, all of that, but I want to see the system get fixed first." And so, while you're molding on that, I'll ask the question to Mark, and then I'll give you a little time to think about your answer. And Mark, I guess the flip side of that question is, what would you say to someone who says, yeah, you make some really good points, but are we really going to deport millions of people? I mean, are we past the tipping point? Are we past the point where we can really do something significant about this, or do we just need to sort of figure out a way to deal with the problem, throw up our hands, whatever? So aren't we too far gone? I think you've heard, are we going to deport all these people? So let's start, Ilya. I'll let you respond first, and then Mark.
Yeah, so I think the answer to a good question is simply that making legal pathways easier is actually the fix. Imagine a policy which said anybody who wants to can enter within the U.S. unless there's evidence that they're doing it for purpose of acts of terrorism or crime or whatnot. Then those other people be able to enter, and the only people who would be trying to enter illegally are actually those who have these other kinds of intentions, and therefore there would be much less in the way of an illegal market, and would be much easier to stop and deal with. Moreover, for reasons I noted earlier, this threat actually is a pretty low one, but we could make it lower still by redirecting resources, vast resources that are currently expended on migration restrictions to law enforcement operations. Doesn't mean that we can eliminate all cross-border crime, that nobody can promise such a thing, but we would have less, and we would have more resources to deal with it. There are some people, there's a different argument from what you suggested, but there are some people who say, well, before we increase legal migration, we got to stop the illegal kind. That's kind of like saying, well, before we end alcohol prohibition, we got to first stamp out all the illegal alcohol smuggling. Only then can we liberalize. It's failing to see that the cause of the current problem under prohibition was the illegality itself. The prohibition regime, and the same thing is true here. When you have a large black market, people can sneak in, including terrorists and criminals alike, but a large black market is an almost inevitable consequence of a regime of migration restrictions, and I would add also of the regime of the war on drugs as well. So if you want to reduce that, you've got to change the regime that caused the underlying problem to begin with.
Mark, do you agree?
Well, we're not as far apart as maybe people would think. But here is the problem, that for so long, there have been promises that if we only do this immigration fix, or if we only do this, then we'll have border security. And the reality is it hasn't happened. And I just want to, once again, kind of go back a little bit in history. The irony is Joe Biden has a bust of Cesar Chavez in Arizona in his Oval Office. And the irony is that Cesar Chavez and his brother were very, very, very anti-immigrant, and they did everything they could to stop illegal immigration. They even organized armed patrols to try to stop people from illegally entering this country. And there was a time in this country before that when you had a Bracero program where people could come to places like Arizona, California, and Texas, and they could work seasonally. And there was not an incentive for people to overstay their visas, to come here illegally. They would come, they'd work seasonally, and they'd go back to Mexico or Central America, and they wouldn't bring their entire families with them. And it was a system that worked. But what happened is that you had people like the Cesar Chavez of the world, you had organized labor that were adamantly opposed to that because they felt like that was suppressing wages, and it also led to the exploitation of workers because if people were in the country, if they were coming in, it undermined their bargaining position. And so I think there is a long-term fix out there because it's happened in the past where it's been able to work. The same side, the flip side of that coin is that, look, we saw during the Trump administration, the numbers were falling. I mean, when you aggressively enforce the law, when you don't create incentives, when you don't have cities or states giving people, $1,200 visa, cards or whatever, you're going to see less of something. I mean, I think the professor and I agree, it's a very common economic principle that if you incentivize something and decriminalize something, you're going to see more of it. And so I think that, ultimately, there could be a fix out there, but I don't think that you can really negotiate against yourself and address that until you address the current crisis at our border. And we throw all these numbers out, but I mean, literally, you're talking about millions and millions of people. I mean, every year, it's like the equivalent of, 3 or 4 United states themselves that are coming in. 5 times population is legal entered this country during the Biden administration that lives in Biden's home state of Delaware. So, I mean, these numbers are overwhelming, and we all get numb to them. But I think, and I don't want to keep harping on this, but it's so important when you go back to law enforcement and the crime. I know that when we were suing the Biden administration, when people at ICE were being deposed, they were saying that they were letting out, as one of our lawsuits, they were letting out people that were charged or convicted of crimes like murder and rape. And even people who were in Arizona prisons, ICE would not come to pick them up to deport them. They were being paroled and let out into our country. And so that's an important point. And the second point is, look, I mean, the way terror cells work, and this isn't a debate about terrorism and national security, we can have another one of those, but the reality is that even the 9/11 hijackers, they were in this country for years. And so, the way terror cells work is they're not going to come over here and the next week something bad's going to happen. But I guarantee you can go ahead and cut this tape. It's not a matter of if, it's a matter of when there will be a major act of terrorism as a result of the open border policies that we have.
I want to shift a little bit. We don't have a lot of time, and and mostly this is something that's been on my mind a lot. So I have a captive audience here, and so I got this job, and it was my dream job, and it still is my dream job. Before I had this job, as General Burbidge will say, we in the state offices we did all kinds of stuff, but we did not do immigration other than sometimes fighting like some of these lawsuits you're talking about. But we didn't do day-to-day immigration. I get on as about 5 years ago or 4.5 years ago as a judge on the Ninth Circuit, and almost half of my docket is immigration, and specifically a certain kind of immigration cases, which are asylum or what we call withholding, which is asylum, essentially another type of asylum, and then convention against torture, which is sort of like another type of asylum, which is basically sort of the fail-safe. You're not going to send somebody back who's got a greater than 50% chance of being tortured back to their country. And one thing I've learned is that, speaking of incentives, whether you come through at a lawful border and you say through a lawful entry and you say, I want to ask for asylum, or you come through and you get captured coming through, or you come through and you sneak through and then you commit some crime and then you're or something happens and you get cited for removal. They'll often make an asylum claim, and what that does is that I think we have some reference to that. That buys you literally years because you go before the agency and you get an appeal before the agency. You get an appeal to the Ninth Circuit. Now, one of the oddities is that where you end up appealing your case ends up going. If your immigration proceedings were in San Francisco, they're going to be in the Ninth Circuit. But if they were in Dallas, they're going to be in the Fifth Circuit, et cetera. And the circuits have, as you might imagine, very different law. So it's sort of the luck of the draw where you're gonna, or at least I guess where you live. And so one of the questions is sort of I wonder about. I would be curious to hear each of your thoughts on this. Is what do you think of this proposal? And it's just a purely selfish proposal on my part, but not entirely selfish. Which is why don't we do two things that I think would help solve this problem? One is why don't we take all of the immigration the petitions for review of immigration decisions from the agency and consolidate them in one circuit. I think that would make sense that circuit would be here in this place, not on the Ninth Circuit. But that would be being selfish. And then, and so, whether it's the federal circuit or whether it's the DC circuit, I hate to throw either one under the bus, but we put all of them, you put all of the petitions there, and that way you have, the uniformity, et cetera, makes sense. And the second proposal is kind of halfway serious with this. What if what happens is folks, they come through, they do, and then they're paroled typically because you can't hold all the people, and so they're just out in society and literally sometimes these people have been here for 10 years when I look at the cases, and they have children and all this stuff. What if we said, well, we'll parole you, but we'll just parole, especially since the court would be here, we'll just parole everybody to the District of Columbia, and you just have to stay in the District of Columbia until, and I feel like that would help the problem to get solved quicker.
You want me to speak first?
Yeah, go ahead.
Yeah. So obviously, if it were consolidated in one
and he
circuit,
clerked on the Fifth Circuit, so I assume that he would have loved to have not had as many of these cases as a clerk.
I can't speak too much to my experience as a clerk because there's confidentiality issues, and the Fifth Circuit judges might not like it. All I can say is that these cases often have a heartrending nature, and when I clerked at the Fifth Circuit, Fifth Circuit, as some of you also hears the most death penalty cases, and people sometimes ask, did the death penalty cases bother you? And the answer, in my case, is generally not, because when you look at what the horrible things that the people accused did, sometimes there's still legal reason to set aside the death penalty, but in general, it did not, hurt my conscience much. On the other hand, immigration cases did, because usually, often people get supported to what clearly are horrible conditions because they didn't fit the technical definitions of what makes you eligible for asylum, which is not just any risk, even of death, or oppression, but only oppression or for a particular set of reasons like racial discrimination, sex discrimination, religion, and some others. So consolidate them all in one circuit, I think you could do that maybe, but you would have to vastly expand the size of that circuit, and also
So a court packing scheme.
Yeah, whichever president was in power at the time, would have a bonanza of new judgeships, or alternatively, maybe judges from some circuits, like the Ninth Circuit, would have to be reassigned to the DC Circuit. So Judge, maybe you would no longer be able to live in scenic Nevada, but would have to live. Would have to move to sort of the terrible, untamed wilderness of Washington D.C. So as to help out with these important immigration cases. I think the proposal to then say all parolees have to be within one small space, I think that's more unrealistic, and I'm not sure whether you seriously mean it or not. But it would just mean more misery for both the parolees and for whoever had to run the facilities in that location. But I will say again, if your goal is to sort of reduce the backlog of immigration cases, if you adopt my rule of a presumption of free entry as opposed to current rule of a presumption of exclusion, then there would be many fewer cases, because only a relatively narrow range of cases would ever have to be adjudicated. Those cases where the government actually say, no, we have serious evidence that you are a criminal or would be terrorist and so on. And I think that reform is probably better than having parole of either the present parole system or one where all parolees live in one place. As to whether it would be better if all immigration cases were heard by one circuit as opposed to being divided over many circuits, I don't know. There's similar debates over other issues. I also do takings. All takings claims against the federal government are actually consolidated in the federal circuit. Is that a good system? I have my doubts, but other takings experts disagree. But whether it would function better in immigration than it does in the area of takings, hard to say.
Well, Mark, I don't like how he perverted my great idea. So what do you think?
Well, I think we all may agree that other than Georgetown, I always say that Washington, D.C. is where good ideas go to die. So I'm not sure if that's the best place, but I think that you were making a facetious point that what we have seen in this country is that when the border crisis first started, when I first started talking about it, even though, like I said, my family fled communism, I'm a first generation American, I was called, a racist and a hypocrite and, a fearmonger, all these things when we started talking about the numbers and what was happening. And as soon as other cities like New York and Chicago started experiencing the impacts of illegal immigration, with not only increased healthcare costs and schools and crime, and then all of a sudden everyone became, a border state and everyone wanted to be a border hawk. And so I think that if you did have a bunch of people that were forced to live in DC, they would, one, realize that, socialism doesn't work anywhere, including in Washington, DC. And that I think that it would catch the attention of a lot of people there to finally maybe address this issue, long-term wise, instead of kicking the can down the road. The second thing is, I actually think that your proposal about I think that's an excellent idea. We see this, there's already immigration courts and, there's bankruptcy courts, there's specialized, courts. You could create a system where you create an appellate process where maybe some experts on some circuit or, that's kind of their wheelhouse, that they maybe do a rotation where those are the kind of cases they handle. And, several years ago, and I can't remember the name of Operation Streamline, I think it was called, but, there was a surge at the southern border. And, this happened during the Bush administration, a little bit during the Obama administration, where they surged prosecutors and judges down to the southern border and aggressively prosecuted people for illegally entering the country. And the numbers dramatically declined because people understood that there was going to be consequences. And so I think there's some examples of you could create or allow some sort of circuit to be able to hear those types of cases. And last thing related to that, I think that's also important is, look, when it comes to amnesty, if you're fearing persecution, international laws, treaties, you're supposed to, claim that in the first safe country, the first safe country of passage. And that's not occurring because the reality is that most people are fleeing economic circumstances. And so if you want to come up with policy solutions, as the professor says, well, then, you know, what you do, we're about the rule of law in the United States. If you don't like the current immigration policies, change the lawmakers. But until that happens, if the federal government refuses to not only not enforce existing immigration law, but encourages and incentivizes and allows the cartels to seize Operation Control of the Southern Border, then the states have a right to protect their residents, the people living there.
Well, thank you very much to both. I was supposed to like allow them time to wrap up and allow you all to ask questions. And I've done a terrible job of moderating as usual, but I do think it was extremely interesting, and I really thank Ilya and Mark for their comments. Why don't you join me in giving a round of applause? And
Well, I think the professor and I are going to take this on the road, and maybe we'll do the death penalty next time.
Thank you all for coming. Really appreciate it.
Thank you. Thank you.
Thanks.
Big time. We're adjourned. Thank you.
Yeah, I will be there. I can't think of a person offhand, but if you're gathering, maybe I'll at that point.